Good morning and welcome to Shift. Well, through the magic of Court TV and the Star Tribune, anyone and everyone really around the world can watch the Derek Chauvin trial, jury selection this week. Court TV, as you told me about, Judge, was the company that did the O.J. Simpson trial. And is
I have to tell you, I'm actually not sure of that. I just said that they selected Court TV, as I understand it. I have no personal knowledge of this. They selected them because they have a lot of experience in broadcasting trials. Whether or not they did the Simpson trial, I just don't know. But
they did.
It is the only source that is broadcasting directly from the courtroom.
Yes, and in fact that this company did the O.J. Simpson trial, and in the what was that, the 90s, and they are I know, and they are
Time
trying
flies
to use,
when you're having fun.
and they're trying to use this really to make a comeback. I read a few articles, and apparently they have 75 people in town, and I looked at their website. And it is a little bit of Nancy Grace type, we're doing this trial and that trial, and here's the Derek Chauvin trial, and, boom, 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 here's what happened. So there is a lot going on in Minneapolis and really around the world. And I believe this is the first time that a state court judge has allowed a trial to be broadcast. And that was really Judge Cahill's decision with the parties' agreement.
In this case, Minnesota is somewhat restrictive in this regard, and unless all parties agree, they have not traditionally permitted video and audio live from the courtroom, television essentially. And in this case, Judge Cahill apparently decided this from the beginning, that this case was going to go, and the parties, I think, either agreed or were handcuffed volunteers.
Right. Yeah. Well, you can see that it might benefit maybe one side more than another. But is that actually true? Maybe it's a little bit of pro and con for each side.
I frankly have no particular sense or reason to believe it benefits one side or the other. The trial is conducted in the courtroom. It is conducted in front of the jurors, who are instructed not to watch on television. And whether or not they feel good when the lawyers feel good when they go home or when they prepare is not part of the proof in the case. So I'm not sure that it benefits either side. It may or may not benefit the public.
Right. So you might look at this outwardly and say, wow, that's really being transparent, which is a buzzword. Everything must be transparent. And is it really, though? Because you can't see everything that's happening.
Well, it's interesting. The courts, in my opinion, have always been the most transparent of any branch of government. They are, by law and constitutionally, our courts are public. If you want to know what's going on in a courtroom, go to the courthouse, open the door, and sit down. You can watch them as many as you want, and as long as you like. Excuse me. But the only thing that you really don't ever see, you don't see the jury deliberate, and you don't see if the judge is deciding the case, him or herself, when they sit in their office and write or type out their opinions. But everything else, the presentation of the evidence, unless it's national security or troop movements in time of war, those trials are wide open, including, by the way, really high national security cases. Sometimes they've excluded missile plans and that kind of stuff. But other than that, the doors are wide open. The reality is, of course, I would guess in substantially over 90% of the cases I tried, other than the parties, the courtroom doors were open, but the gallery seats were empty. 26,000 years ago, when I was a young lawyer down in Chicago, there were a group of mostly old men who used to keep track of the trials, and they were court watchers. This was their, I think, their retirement hobby. And you kind of learned, or you felt that you had maybe arrived when they wanted to come and watch your trials. But, it's a great show. The other thing is, and let me shift to television. Television shows you a picture. It may be a lawyer who's asking a question. It may be a juror who's watching. They don't show pictures of jurors. It may be the judge who's presiding. It might be the witness who's testifying. But a trial is really an immersive experience. It is all of those things as they happen simultaneously. And yes, you get a picture, but it's more like you're looking through a keyhole.
So if I tune in and I hear and see one of the attorneys say to a 19-year-old, do you think you could be fair? And I hear the 19-year-old and he's like, they ask some really tough questions.
They do, and they should. By the way, that question is as difficult to a 19-year-old, I assume, as it is to an aging jurist. Whether or not you can be fair is a fundamentally very hard question to answer honestly.
How do you find people who can be fair? Are there people who can be?
To some extent, it's a belief system, and the answer is I believe that you can. There are certainly people who have a contrary view, but I mean, I would have tried cases involving drugs as a convenient example, and a juror or potential juror will raise his or her hand and say, I'm really opposed to drugs. And that's not the question in the case, and I will explain that to them. The question in the case is not whether you like drugs or whether you hate them. That's your choice. It may be illegal to use them, but you can like or not like whatever you want. The question is, did this person do what they are accused of as was charged by the government? Which is a different question completely than whether or not you like drugs. I used to also say, I assume you would tell me you're opposed to murder. The question is not whether you're opposed to murder. I suspect most people are. The question is whether the person committed one. It's a different analysis and a different question.
So that gets to me a little bit to our faith. We're a Lutheran church doing this, and our pastor told me yesterday, he said a trial is much like our faith. We need to trust in the process, and we are not the judge and the jury, really, nor can we predict the future.
As we used to say in court, there's no question before the witness. I probably lack a certain amount of experience in Lutheran ecclesiastics, but the answer is it is a process, and a rather well refined. It's gone on, going back in English law somewhere to the 1200s, and it is, I believe, about as fair as a human system can be. Do humans make mistakes? They always have, but as close to either perfection or at least operational capacity as we can develop. And many wise people have said that cross-examination is the finest engine for divining the truth as is available.
So if you're running this show, what is it like to be the presiding judge?
That's a really interesting question. To some extent, you're almost like a theater director. There are a lot of people simultaneously playing the roles that they must play. There's the judge who presides, but the lawyers have an obligation, a dual obligation. Their obligation is, of course, to their client, but their obligation is also to the legal process. It's a fight, but it's not a food fight. And they are entitled and obligated to press for their client's interests as far as they possibly can within the confines of the rules. And they're entitled, there's some banging under the basket from time to time. That's permitted, including objecting to what judges do, including objecting to what the opponents do, including objecting or being concerned about what a witness might do. The jurors have their own obligation, and the judge's job is to kind of keep the whole thing going and maintain the legal processes that help assure that you'll get a just outcome.
You and I tuned in a little bit yesterday. Any thoughts about it?
I should point out, I have not been watching. I spoke to you yesterday. You sent me a link. First of all, this is jury selection. Jury selection is not perhaps the most exciting aspect of a trial. It has its own relevance, its own object. But first of all, probably 70% of the people, whatever happened is going to go away because they're not going to be selected. So you spent 40 minutes questioning somebody on various subjects, and thank you very much. Get rid of that, and now you go on to the next person. It's a very interesting process. Each side wants to whatever extent they're permitted, either by law or by the judge, to try and probe on the subjects of their interest, or on the subjects that may be coming up during the trial. But on the other hand, as we spoke about previously, you don't get to pick your jurors. You get to unpick potential jurors. You can say, I don't want that one, but you can't say that's mine, I want him or her. And it becomes quite subtle. You also want to make sure that the other side doesn't really know that you want them, because they'll knock them off if they think you want them. I also, there was one other that I did happen to see, and it happened because it just was when I turned on the feed. They had a young woman, apparently, I don't know, young or old, I didn't get her age, and you don't see her, but she's an attorney. And I have had attorney jurors. I've had attorney jurors in trial. I've had attorney jurors in grand juries also. And an attorney is a different aspect because they are trained in the law. Now, most lawyers, heaven help us, are not trial lawyers, which is probably a good thing for all of us, but that's another subject. But they have, if you will, a training in a certain form of expertise. And whether or not you want somebody like that on your jury, or whether you think that's too risky, or which side thinks that's too risky, is a very tricky question. A collateral of that is, for instance, and one of the reasons is it's a problem, is it can lead, or it's believed that it may lead to what's called a one-person jury. They are trained in the law. The other jurors, even though they will be instructed that they shouldn't, and the lawyer is also instructed that she or he shouldn't, turn to them for any kind of expertise. But there is a natural tendency, if you're in a medical malpractice case and there's a doctor on the jury, you'd say, well, doc, what do you think? And you may not want a one-person jury. Sometimes, I mean, there's all kinds of different theories. I feel like I'm running on too long here, but there's all kinds of different theories about who you'd want. You might not want a drill sergeant or a senior corporate officer. Why not? Because they're very good at organizing people. In criminal cases in particular, you do not want a happy juror. Because the only way you can be convicted is by a unanimous jury. What you'd really like is somebody who won't talk to anybody, somebody who won't go along, because then you can't be convicted. As long as they hold out, 11-1 is not going to do it. So and of course you don't know for sure how they're going to operate when they're in that closed room. So it's a chess game where you don't know how many pieces there are, and you're not sure how big the board is, and you don't know what the other side is playing the game either.
Do you think that the jury selection is going fairly quickly?
Well, I don't know. What have they got now? 4 or 5 jurors selected, apparently. It's a process. And once, at least in my experience, and I think to the extent that this seems to be going faster than had been predicted, it's not surprising to me. Once the game gets going, once the court starts operating, the parties and the judge move it along, and they're used to this process. So the fact that they may select this jury faster than had been expected is not surprising to me.
We hope that this has been useful to people who are watching, and I know it has been to me, Judge. You provide insight and information that I don't hear elsewhere, and we really appreciate it and hope to have you back.
Thank you. Let me throw one more thing in, because I said something that matters to whatever extent the things that I say matter at all. But I said before the jury is sworn, potential jurors, when they're examined, are sworn to tell the truth. They're obligated to respond truthfully on the survey that they received and to the questions that are asked by the judge and the lawyers. But when the jury is all selected, when there are 12 or 14 or 16, however many jurors there are going to be, 12 jurors plus alternates, they are sworn to follow the law. And at that moment, what is called jeopardy attaches. And at that point, the trial has begun. And if after that, a person is not to be subjected to double jeopardy, you cannot be tried twice for the same crime. The trial starts when the jury is sworn. Okay. And with that, thank you. It's a pleasure. I make it very clear. I have neither expertise nor experience in this trial. I haven't been following it in that fashion, but I guess I've done a few cases in my life.
Yeah, just a few hundred. So thank you, Judge. It's so good to see you again.
Thank you. My pleasure. Take care.
Thanks, everyone.